Today we are going to learn and understand the decisions of 9 SCOTUS landmark decisions that still influence how certain things are run today in America. Our first category will be freedom of religion. The first thing that pertains to the freedom of religion is the 1962 case of Ingle v. Vitale. Let's start with the background of the case, shall we? Very simply, the New York State Board of Regents put into place a voluntary non-denominational prayer to be said at the start of school along with the Pledge of Allegiance. A group of parents sued the school board, claiming that the prayer violated the Establishment Clause of the First Amendment, which is what the case revolved around. It was rejected by the New York Court of Appeals, leading to the case being brought in front of SCOTUS. The Supreme Court of 1962 was liberal, headed by Chief Justice Earl Warren. The main question of the case was established to be, did school-sponsored prayer in public schools violate the Establishment Clause of the First Amendment? The ruling pertaining to the question? Yes. With the decision being 6-1, the majority opinion held that the recitation of a prayer in school blurred the line between the separation of church and state, as the prayer was written by the government and used as a governmental program. Justice Frankfurter did not participate in the vote as he had suffered a stroke, and Justice White did not participate because he was recently appointed. It was also noted by the majority that as Americans have a very diverse set of religions they adhere to, it would be unfair for the government to endorse a specific religion or a set of beliefs. Conflicts have arisen due to the government meddling in religious affairs across history. In a concurring opinion by Justice Douglas, he wrote that the Establishment Clause would also be violated when the government gives money to religious schools, and the Establishment Clause required the government to be strictly neutral in religious affairs. A dissent was submitted by Justice Stewart, who argued that the prayer was voluntary, therefore not establishing an official religion. No precedents were overturned in this case. The holding of Ingle v. Vitale prevented the government from supporting a specific religion and cemented the separation of church and state. This case has been cited in many other SCOTUS cases, including Avington School District v. Shemp, the reading of the Bible before the pledge is non-constitutional, and Santa Fe Independent School District v. Doe, where student-led prayers before football games are unconstitutional. Our next case related to religious freedom is the 1972 case of Wisconsin v. Yoder. The Amish are a group of people known for their Anabaptist, traditionalist beliefs and their aversion to modern technology. They also believe that higher education would endanger an individual's chances to achieve salvation, leading them to pulling children out of school around the age of 14. A Wisconsin law requires students to remain in school until the age of 16, and convicted 3 Amish parents for taking their children out of school after 8th grade. The parents then proceeded to sue, claiming that their right to free practice of religion was violated by the law. Wisconsin appealed to SCOTUS after the Wisconsin Supreme Court ruled in Yoder's favor. The Supreme Court of 1972 was liberal and led by Chief Justice Warren Burger. The main question at the heart of this case is, did Wisconsin's compulsory education law violate the First Amendment right to free practice of religion? The First Amendment, specifically the Free Exercise Clause, is examined in this case. The decision was unanimous in favor of Yoder. The majority opinion held that an individual's right to practice religion trumps the state's interest in this case, and that the decision didn't affect the law relating to non-Amish people. Both Justice Powell and Rehnquist didn't vote as they were not yet on court. In a partial dissent, Justice Douglas wrote that the decision was only based on the opinions of the parents, with no regard to the children in the scenario. He considered sending the case back to the lower courts for the opinions of the children. This case did not overturn any precedents. The holding of Wisconsin v. Yoder is often said to be the basis of homeschooling children rather than enroll in a public or private school. It also prevented the government from interfering in religious practices. SCOTUS cases related to Wisconsin v. Yoder include Employment Division v. Smith, which created a standard where religious practice could be restricted by the government, and Kennedy v. Bremerton School District, where the government cannot restrict personal religious practices in school. The first case that is under the freedom of speech is the 1969 case of Tinker v. Des Moines. A group of students wore black armbands to school as a form of peaceful protest against the Vietnam War. The Des Moines School District, after hearing of the intent, created a policy that any student that wore an armband or refused to take it off would be suspended. The parents sued the school district for violating the students' right to free speech, appealing to SCOTUS after the district and circuit courts ruled in the school's favor. The Supreme Court at the time was liberal and headed by Chief Justice Earl Warren. The main question at the center of the case was, does banning the wearing of armbands as a form of symbolic speech violate the students' right to freedom of speech in the First Amendment, with the First and 14th Amendment being scrutinized? The decision was 7-2 in favor of Tinker. The majority opinion held that students retain their constitutional right to free speech when they are in school, and the wearing of armbands is a form of speech meant to show their views of the Vietnam War. Concurring opinions include Justice Stewart, who wrote that the entirety of the First Amendment rights aren't guaranteed to children. Justice White wrote that the majority's conclusion was based off of the differentiation of communication through words and through action. Justice Black and Justice Harlan dissented, with Justice Black authoring the primary dissent, arguing that the First Amendment did not necessarily mean that you can express your opinion at any time, as wearing the armband to school is disrupting the school environment. The Tinker test was established after the ruling, which is a standard to determine the extent of students' free speech in schools. SCOTUS cases related to this case include Papish v. Board of Curators of the University of Mississippi, which ruled that kicking out a student because they can publish something considered indecent by the school is unconstitutional. Bethel School District v. Fraser, which ruled that suspending a student for making a speech with sexual overtones is constitutional, and Hazelwood v. Kohlmeyer, which ruled that schools can regulate content of school newspapers. Our second case relating to freedom of speech is the 1919 case of Schenck v. United States. Charles Schenck, a socialist, was charged with conspiracy under the Espionage Act of 1917 for handing out leaflets encouraging men to dodge the World War I draft peacefully. The Espionage Act, as mentioned before, criminalized interfering with the operation of the army and to convey false reports or statements with the intent to affect the army. He appealed to SCOTUS after his conviction, arguing that his First Amendment right to speech was violated. The Supreme Court of 1919 was liberal, led by Chief Justice Edward Douglas White, Jr. The major question asked was, did Schenck's conviction under the Espionage Act, criticizing the draft, violate his First Amendment right to freedom of speech, and is scrutinized under the First Amendment and Espionage Act? The decision was unanimously in the United States' favor, with the majority opinion holding that the action has to be also aware of the circumstances where it was done. Speech that possesses clear and present danger is okay to be controlled by the government, especially during wartime. Justice Holmes very famously compared it to shouting fire in a crowded theater, as free speech wouldn't protect the guy from indirectly killing people in the ensuing stampede right after. No precedents were overturned. The holding of this case established the clear and present danger test, although it was largely replaced by the imminent lawless action test of Brandenburg v. Ohio, which was ruled that a KKK member had the right to free speech. The Espionage Act still remains in place today, with people like Chelsea Manning and Edward Snowden being charged under it for leaking government documents. Our next category relates to freedom of the press, with the only case under it being the 1971 case of New York Times Company versus United States. Daniel Ellsberg, who was a military analyst, after becoming disillusioned with the Vietnam War, leaked over 7,000 pages worth of documents related to American involvement in the war, then kept at Rand Corporation. Known as the Pentagon Papers, they were also leaked to publications such as the New York Times and Washington Post. An editor who received the lead knew he had a story of the year if he published the article in the New York Times, but it could potentially violate the Espionage Act, which was mentioned in the last case. The New York Times published 2 articles anyways, and got sued by the U.S. government. This case was argued with the Washington Post, as they had also published articles on it. The Supreme Court of 1971 was liberal, headed by Chief Justice Warren Burger. The major question asked was, did the government's efforts to prevent the publication of leaked information, what they termed as classified information, a violation of the First Amendment? The decision was ruled 6-3 in favor of New York Times Company, with the per curiam stating that the U.S. government did not meet the burden of proof to use prior restraint to control the publication of the Pentagon Papers. Justice Black, joined with Justice Douglas, wrote that the court can never restrict the publication of news because the freedom of press is absolute. Justice Douglas, joined with Justice Black, wrote that the executive branch didn't have any inherent power to protect national security enough to justify prior restraint on publication. Justice Brennan emphasized that it was the first time in American history that the government had tried to restrict information published by newspapers, and that there was only one very specific exception to the prior restraint doctrine, imminent threat during war, that didn't apply to this case. Justice Stewart, joined with Justice White, understands the government's reservations about secrecy, but it's really the executive branch's own responsibility to protect their secrets, and that as the leaks didn't really pose a direct, immediate, and irreparable harm to America or its citizens, prohibiting publication would violate the First Amendment. Justice White, joined with Justice Stewart, wrote that he didn't think the First Amendment allowed for people to publish information on government plans, and that the government could possibly punish the people who published it, but it doesn't justify their prior restraint on the publication. Justice Marshall wrote that there wasn't a statute that allowed the legislative or executive branch to restrict information on the basis of national security, and that they didn't have power to issue something similar. Also, punishment related to this doesn't mean they could restrict. As for the dissents, Chief Justice Burger wrote that the decision was rushed, and that there weren't enough facts to make a decision, which was technically true. The decision was argued and passed in less than a week. Justice Hurlin, joined by Chief Justice Burger and Justice Blackmun, also agreed with Chief Justice Burger that the decision was rushed, and that the judiciary branch shouldn't question the executive branch on matters such as this. Justice Blackmun wrote that the First Amendment is only part of the Constitution, and that other parts of the Constitution stated that the executive branch is responsible for the nation's safety. This case did not overturn any precedents. New York Times Company versus United States established the precedent that limits the power of the government to restrict freedom of the press, upholding the First Amendment's protection against the prior restraint, especially as the prevalence of whistleblowers began to rise in recent years. SCOTUS cases related to it include Neer versus Minnesota, where a guy was convicted after writing an article criticizing the Minnesotan government, because the Minnesotan government made it illegal for one to criticize the government. The ruling of this case extended the right to freedom of the press in the states as well. The next category concerns the right to bear arms, again only having one case under it, the 2008 case of McDonald versus Chicago. In 1982, Chicago put out a handgun ban, requiring anyone who owned one to register it. As it was a pain in the neck to do so, citizens in the city were virtually banned from having a handgun. After the decision for Heller versus D.C., where the court found that a law that strictly regulated gun ownership was unconstitutional came out in 2008, citizens of Chicago sued, as it violated the 14th Amendment that extended the right to bear arms to state and local governments. The Supreme Court at the time was conservative, headed by Chief Justice John Roberts. The main question at the center of the case was, does the Second Amendment apply to the states based on the 14th Amendment, leading to limitations on Chicago's ability to regulate guns? The court ruled 5-4 in McDonald's favor, with the majority opinion holding that the Second Amendment was fully applicable to the states under the 14th Amendment, and that self-defense was a basic right. 4 out of the 5 in the majority also stated that there can be reasonable restrictions on guns. Dissents include Justice Stevens, writing that the 14th Amendment was created to protect the states from the federal government, so it doesn't make sense when it's implied in reverse. Justice Breyer, joined by Justices Sotomayor and Ginsburg, wrote that the Second Amendment shouldn't be incorporated into the states under the 14th Amendment because it's not a need for people to have guns for private self-defense. The decision of McDonald versus Chicago overturned decisions such as United States versus Cruikshank, where it was ruled that the First and Second Amendment are only applied to the federal government. Presser versus Illinois, where it was ruled that the states may forbid private armies and that the Second Amendment was only applicable to the federal government. The holding of the case ruled that the Second Amendment also applied to the state government, allowing for people to challenge state and local laws on gun bans. The next category relates to the right to an attorney, again with there only being one case under it, the 1963 case of Gideon versus Wainwright. A pool room was burgled in Florida, and the police apprehended Clarence Gideon after he was found as chained in his pockets. As he was too poor to afford a lawyer, he asked the Florida court to appoint one for him. They refused because one is only appointed a lawyer in capital cases where the penalty could be death. He defended himself in court, leading to a 5-year term in prison. As he was in jail, Gideon studied law and came to the conclusion that his rights were violated due to him not having a lawyer in defense. He filed a habeas corpus to the Florida Supreme Court, which was ruled against him. He then handwrote an appeal to SCOTUS. The Supreme Court at the time was liberal, with our best bud, Chief Justice Earl Warren, heading the court. The main question surrounding the case was, does the Sixth Amendment's right to counsel extend to crimes where the death penalty is not considered, with the Sixth and 14th Amendment being examined in this case? The decision was unanimous in favor of Gideon, with the majority opinion holding that the right to counsel was a fundamental right critical to a fair trial. Concurring opinions were submitted by Justices Douglas, Harlan, and Clerk, mostly related to how it overturned a precedent set only 14 years before, and if the 14th Amendment applied the entirety of the Bill of Rights to the states. The holding of Gideon v. Wainwright overturned the ruling of Betts v. Brady, with the circumstances being terribly similar, with only the court ruled in the respondent's favor instead of the petitioner's favor. The ruling is heavily relevant today, especially due to the ever-widening poverty gap and systemic racism, and has led to the creation of the Criminal Justice Act. Similar SCOTUS cases include Poa v. Alabama, where the court ruled that to have a lawyer is fundamental for a fair trial, and that a trial judge must inform defendants of this right. Johnson v. Zerbst, where the Supreme Court ruled that the petitioner had his Sixth Amendment rights violated because he did not have a lawyer at his trial. And finally, in Gold, where SCOTUS ruled that minors also have the right to due process under the Fifth Amendment and the right to a lawyer under the Sixth. The right to privacy category also only contains one case that has since been overturned, the 1973 case of Roe v. Wade. Jane Roe, which is a pseudonym, wanted to have an abortion in Texas, where it was a felony to abort a fetus unless for serious medical reasons. She sued Henry Wade, the district attorney for Dallas, and challenged the state laws, which she claimed were unconstitutional and restricted her right to personal privacy. The Supreme Court at the time was liberal, being headed by Chief Justice Warren Burger. The major question, plain and simple, was, does the U.S. Constitution protect a person's right to abortion, with the 9th Amendment and 14th Amendment being examined? Slightly less related, but still brought up, were the 1st, 4th, and 5th Amendments. The decision was 7-2 in Roe's favor. The majority wrote that a person's right to privacy was stated in the 14th Amendment, where the liberty stated also extended to privacy. In the first trimester, a person's interests outweigh the state's interests. States may regulate abortions in the second trimester as the fetus becomes more developed and the risk for abortions becomes higher. The state can regulate or ban abortions in the third trimester as it poses a danger to pregnant women. Concurrences include Justice Stewart, who wrote that the court was basing off his holding on the supposedly substantive part of the Due Process Clause. Justice Douglas rejected Justice Stewart's reasoning of the substantive Due Process Clause, but he did agree that the constitutional right was based off of the word liberty in the 14th Amendment. Chief Justice Burger emphasized that the court does not require abortions on demand. Dissents include Justice White, joined by Justice Rehnquist, with him not finding anything related to the constitutional right to abortion in the Constitution. Justice Rehnquist filed a separate dissent, arguing that abortion did not fit in with the definition of privacy recognized in precedent cases. Roe v. Wade did not overturn any precedents, but was overturned by Dobbs v. Jackson Women's Health Organization in 2022. Roe v. Wade was overturned by Dobbs v. Jackson's Women's Health Organization, which challenged Mississippi's 15-week abortion ban. It led to the decision that abortion was not a constitutional right or a fundamental right by a vote of 6-3. This has led to significant cultural changes in the U.S., with 16 states strongly regulating abortion access. Finally, our last category is related to equal protection, with the only case under it being the 1954 case of Brown versus Board of Education. Linda Brown and her sister had to walk and take the bus to a school for black children, Monroe Elementary, when she lived much closer to a school for white children. She tried to apply for the white-only Sumner Elementary, which was ultimately rejected because of race due to the enforcement of segregation, which is separation by skin color. Her parents and other parents sued the school district as it denied the right to equal protection under the Constitution. The lower courts denied that it was a violation of Brown's rights, as Plessy v. Ferguson established the separate but equal clause. The case was then appealed to the Supreme Court. The Supreme Court at the time was liberal-leaning, headed again by our friend Chief Justice Earl Warren. The main question at the center of the case was, does the segregation of schools based on race violate the Equal Protection Clause of the 14th Amendment, with special attention being paid to the 14th Amendment? The decision was unanimously in favor of Brown, with the majority opinion being written informally as to allow non-academic and law nerd people to also understand the importance of the holding. The majority maintained that separation of children based on race was inherently unequal and has created a sense of inferiority among the black children that has had a huge negative effect on their education and growth. Brown v. Board of Education overturned Plessy v. Ferguson, the basis for the separate but equal doctrine. Cumming v. Richmond Board of Education, which ruled that the use of Richmond County funds for white-only schools was perfectly constitutional. And Barrier College v. Kentucky, which ruled that states can legally prohibit private schools chartered as corporations to prevent racial desegregation. The holding was signed and agreed by all 9 justices, which acknowledged the importance of this decision. All segregation by law today, de jure segregation, is unconstitutional, but schools are still mostly made up of students from one racial background because of socioeconomic backgrounds, leading to de facto segregation, which is segregation not by law.